It was a day of surprises in Pretoria. Firstly, no union protesters for the first time in more than a week of hearings. Apparently, they were away on election duty. Inside, the second surprise, an indication from the Competition Commission that it believes the retrenchment of 503 workers by Massmart was done so with the deal in mind.
In the Commission's view, the inference is therefore irresistible that the retrenchments were linked to the merger. In those circumstances, the Commission recommends that the merger be approved with the following conditions: that all the 503 employees who were retrenched be reinstated.
The merging parties' lawyers argued against this, saying it was beyond the tribunal's powers, bearing in mind the retrenchments had been approved by arbitrators in the Labour Court. They also argued for the deal.
There is an overwhelming case that there will be very significant consumer welfare gains that flow from this merger by way of the price reductions that will accrue from the acquisition that is contemplated, and those will be widely enjoyed by members of the South African public. It is also a consequence of that there will be employment gains that accrue for the benefit of the economy as a whole.
But the unions remain dead against it. Michael Bride, who represents 1.3 million members of the Union of Food and Commercial Workers in the United States, is here to advise South African unions.
The philosophy of this company that we've seen in North America, the Wal-Mart business model, is to drive down costs at every single element of the business that it possibly can, including labour costs right across the business.
In the afternoon, Massmart played its trump card, voluntary restrictions. No staff reductions for 2 years, an agreement to honour labour agreements. Investment of 100 million rand over 3 years to develop suppliers. Also, a plan to talk to the 503 retrenched workers about re-employment.
What we're doing now is, in order to demonstrate we're confident about our commitments about what we intend to do, we're offering them up on the record and for the tribunal to make them conditional upon the deal, so no one can doubt our sincerity that we intend to do what we say.
I think it's instructive to note that those conditions waited until the 11th hour before they were put forward, were not put across the table with the trade union in order to allay its fears, were not put out in the course of the tribunal last week, and instead at the 11th hour, in a separate document to its main submission, the merging parties belatedly put forward these voluntary conditions.
I think that's just not true. It may be true in this hearing, but we reserve our right to legal tactic.
The South African economy will eagerly await the result. So for the next 10 days, the Competition Tribunal has the devil's own job. If it allows the deal to go through without stringent conditions, it's likely to upset the unions. Remember, most union members want to see this deal scrapped. If it does impose stringent conditions, there is a chance it could upset international investors.